Hey there, Scott Shoemaker here. I am an estate planning attorney in Cedar Rapids, Iowa, and I hope you are having a fantastic day. One of the questions I get a lot is whether or not you need a notary for your will. And it's kind of a confusing question because it's a little bit nuanced. Generally speaking, at its most basic level, a will does not need to be notarized. What makes it tricky is the fact that a will needs to be witnessed. And you typically, under Iowa law, need to have two disinterested witnesses witness the signing of a will. Now, the reason I think that gets confused a lot of the times is because really what a notary is an official witness for the signing of documents. But strictly speaking, a notary is not necessary under a will. Now, what sometimes happens is, in addition to your will, which you sign and is witnessed by two disinterested witnesses, is you often have a self-proving affidavit. And what this is it's a sworn statement saying that your signature and the signature of the witnesses on the will itself are authentic, valid signatures. And the reason we do this is to prevent people from having to go to court in order to prove the authenticity of the signatures that are on a will. And for that, when you have a self-proving affidavit, that typically does require a notary. And so a lot of people sort of blend those two ideas together, the affidavit and the will, and they come to the conclusion that a will requires a notary. But that's actually not the case. A will simply requires two disinterested witnesses. The self-proving affidavit requires a notary. And so oftentimes you have a notary in the will signing process, but it's not the same as having a notary witness or a notary notarize your will.